the state of Maharashtra. No quarrel. I have paid it and there is no dispute. Petitioner wrote to the Principal Secretary, Department of Commercial Tax, Government of Madhya Pradesh, and informed the Principal Secretary. The order dated 15/2/2017 passed by the NCLT Mumbai, thereby sanctioning the scheme between JAL and JCCL, that as per the notification dated 3/7, the stamp duty payable has been capped at 25 crore. The petitioner is willing to pay the aforesaid stamp duty. In this representation, the petitioner also highlighted the fact there was another act, my lord, another cess, imposition of 1% cess on the value of property, subject to the instrument under Section 75 of the Madhya Pradesh Panchayat Raj Act, will defeat the object of capping the amount and therefore ought to be relaxed. That was a representation. I made a representation. I didn't bring the document of NCLT Allahabad into Madhya Pradesh. I made a representation to the Principal Secretary. 111, petitioner deposited a sum of rupees INR 32.37 to Mumbai. 19/7/2018, petitioner made a representation to the Honorable Chief Minister of Madhya Pradesh, seeking his intervention on the matter of imposition of Janpad cess at 1% on the sale value of the property. It was submitted that the government may consider issuing a notification capping the same at 1% of the stamp duty. This is again a representation. 6/10/2018, petitioner's representation was accepted by the state government of Madhya Pradesh, and it was directed that Janpad cess was to be collected at 1% of the stamp duty from the petitioner. This is a specific order relating to me. 30/7/2019, Office of District Registrar, District Siddhi, directed the petitioner to submit copies of orders passed by NCLT Mumbai and NCLT Allahabad, pursuant to which it has taken over the unit of JAL located at Bela and Bagwar. This is the crucial data in my submission. 5/8/2019, petitioner by reply submitted a copy of the following. Order dated 15/2/2017 passed by NCLT Mumbai. Order dated 2/3/2017 passed by the NCLT Allahabad. Receipt of payment of stamp duty in Mumbai. Form INC 28 submitted to the Registrar of Companies through the portal of Ministry of Corporate Affairs. But for the second submission of legal, I'm submitting. I brought the document into Madhya Pradesh only on 5/8/2019. And under the law settled by your lordships, this is the relevant date. 23/1/20, the DIG registration Jabalpur. My lord, he is a superior officer to the collector of stamps. DIG registration Jabalpur issued a letter to the registration office, District Siddhi, directing it to recover stamp duty, mark, my lord, on the NCLT Allahabad order, dated 2/3/2017, from the petitioner under Section 19A of the Indian Stamp Act. See, he only mentions the NCLT Allahabad order, presumably because the NCLT Mumbai order had been stamped in Mumbai. And the NCLT Allahabad order had not yet been stamped. It was pending in Uttar Pradesh. In the said letter, the DIG Jabalpur observed that, my lord, much of it is wrong, but I'll read it. NCLT Allahabad, while order dated 2/3, accepted the scheme of arrangement pursuant to which the assets of JAL and JCCL have been transferred to the petitioner. The aforesaid order is an instrument and therefore is liable to payment of stamp duty. The order of NCLT Allahabad instrument has not been registered by the petitioner. Rather, the petitioner has got the order of NCLT Mumbai registered, whereby no transfer of any assets has been effected. Wrong. This has been done to avoid payment of stamp duty. Respectful submission is hopelessly wrong. I was not trying to evade duty. I have paid the stamp duty in Mumbai. I was in the process of paying the stamp duty in Allahabad once it's adjudicated. When I bring it into Madhya Pradesh, I will submit it to the law of Madhya Pradesh. 24/2/20. Pursuant to the directions issued by letter dated 23/1, the Collector of Stamps, District Siddhi, issued a notice under Section 48B, read with Section 40 of the Indian Stamp Act, directing the petitioner to produce the original copy of the instrument order dated 2/3/2017, passed by the NCLT Allahabad. My lord, in the court matters, there is no original copy. It's only a certified copy. And I have certified copies. There is no original copy like a lease deed or a sale deed. There is an original copy and you make subsequent copies. It's either a certified copy or it's not a certified copy. Be that as it may. Petitioner filed a detailed reply on 5/8. State Government of Madhya Pradesh issued a notification dated 25/8/20 in the official gazette, directing collection of Janpat Cess at 1% of the imposed stamp duty from the petitioner. This relates back to the acceptance of my representation, serial number 13, on 6/10/2018, previous page. 6/10/2018, they wrote a letter accepting my representation. My lord, in the formalized it by a notification on 25/8/20. Now, kindly see that order, my lord, so that we can put it out of the way. At page 375, annexure P40. That controversy can be settled. In context of Section 75 of the Madhya Pradesh Panchayat Raj and Gram Swaraj Act, the state government hereby decided that 1% amount of the imposed stamp fees shall be taken from the applicant company, Messrs. Ultrasec. Well, this is not a general order, this is a special order. Now, if I may continue. Petitioner filed an application before the Collector of Stamps, Bulandshahr, Uttar Pradesh, under Section 31 of the Indian Stamp Act for adjudication of stamp duty on the order of NCLT Allahabad. Petitioner informed respondent 2 regarding the filing of the application before the Collector of Stamps, Bulandshahr, for determining the stamp duty and requested that the proceedings initiated by him by a show cause notice to which I had replied, he stayed till determination of Collector of Stamps, Bulandshahr. I said, you please wait, let the NCLT Allahabad, which is the collector of, which is the order which is produced before the Collector of Stamps in Allahabad, in Bulandshahr, where the immovable property is, let it be decided and then you may continue. I write it on 19/10. On 24/10, without further ado, he issued a show cause notice on 24/2. I file a retail reply by 5/8/20. No hearing, etc. When I move Allahabad or Bulandshahr, Uttar Pradesh Authority, I bring it to his notice on 19/10. Please stay your hands. I will get the Bulandshahr order and I'll produce it. 5 days later, he passes the impugned order demanding a total sum of 297 crore. Now it breaks up in the following manner. Over the page. Stamp duty INR 123 crore at the rate of 5% on the immovable property. He ignores the cap. 2. Stamp duty of INR 6 lakhs, the small amount, at the rate of 1% on movable assets. The proviso only applies to immovable property, does not apply to movable property. Upkar Cess of INR 12,30,000 at 10% of stamp duty.
12 crores, 30 lakhs.
12 crore at 10% on stamp duty. I'm not disputing the 10%. I'm disputing the stamp duty. There's no quarrel about the rate because I had not got a relaxation for that rate. Janpad Cess of INR 24 crore at the rate of 1% of the value of the immovable assets. He ignores the government notification, 1% of stamp duty. And penalty of INR, what did I do wrong? I brought the document and I offered to pay tax. Why? What a penalty for? Miller, A is hopelessly wrong. B is without jurisdiction. C, the rate is admitted, but the base is disputed. D is hopelessly wrong. It's 1% of the stamp duty. And E is completely without jurisdiction and arbitrary. And its lordship will note as a matter of interest, 137 crore is more than the stamp duty 123 crore. I'll show the provisions below. So this is a hopelessly bad order. And he should have, once he issued a show cause notice, and I'll show you, take your lordship through the show cause notice and the reply. He should have given me an opportunity. This is what I propose to do. What do you have to say? Anyway, writ petition filed to quash the impugned order and hold that the petitioner is not liable to pay stamp duty in Madhya Pradesh on NCLT Allahabad in view of the provisions of the Indian Stamp Act as applicable. That is the preamble. Application filed on behalf of the petitioner to place on record the following. Chartered accountant certificate certifying the net movable and immovable assets of Bela plant and Siddhi plant. Brief note of arguments. This honorable court passed the interim order staying the impugned order on 24/10. Now kindly see the interim order. I think it's in your lordship's file. Well, it was contested at that stage. Maintainability of the writ petition was raised and a learned single judge of this court held that the writ is maintainable. And may I read portions of that order? My lord has got the order. Okay. Petitioners have filed the present writ petition challenging the order, 297 crore. It is submitted by learned senior counsel appearing for the petitioners that scheme of arrangement was brought in state of MP on 24/10/2017, and therefore this is the date which has to be considered for levying stamp duty. It is further argued by learned senior counsel of the petitioner there is 25 crore as the maximum stamp duty, etc., etc. Learned senior counsel appearing for petitioners further submitted that collector of stamp is further committed in illegality in ignoring the notification of 27M. Various arguments. Counsel appearing for the state government opposed the prayer for grant of stay on the ground that the petitioner has alternate remedy available to him. Deputy AG relied on judgment passed in writ appeal. It is argued by learned senior counsel that collector has committed an error of jurisdiction, and this court can entertain the writ petition on his discretion, despite availability of alternative remedy. Learned senior counsel has relied upon the judgment reported in 2018 4 SCC 720. May I read that? Because the next judgment follows that. We may, however, consider a hypothetical case. Supposing the correct value of a property is rupees 10 lakhs, and that is the value stated in the sale deed, but the registering officer erroneously determines it to be 2 crore. In that case, while making a reference to the collector under section 47A, the registering officer will demand duty on 50% of 2 crore, that is duty on rupees 1 crore, instead of demanding duty on rupees 10 lakhs. A party may not be able to pay this exorbitant duty demanded under the proviso to section 47A by the registering officer in such a case. what can be done. In our opinion, in this situation, it is always open to a party to file a writ petition challenging the exorbitant demand made by the registering officer under the proviso to Section 47A, alleging that the determination made is arbitrary and or based on extraneous considerations. And in that case, it is always open to the High Court, if it is satisfied that the allegation is correct, to set aside such exorbitant demand under the proviso to Section 47A of the Indian Stamp Act by declaring the demand arbitrary. It is well settled that arbitrariness violates Article 14 of the Constitution. That is, then subsequent judgment quoted the earlier judgment, and then over the page, paragraph 28, in our view, therefore, the learned single judge should have examined the facts of the present case to find out whether the determination of value of the property purchased by the appellant and the demand for additional stamp duty made by the appellant by the additional collector were exorbitant so as to call for interference under Article 226. Heard the counsel, objection raised by the learned Deputy AG appearing by the state is overruled. This court has discretion to entertain a writ petition despite availability of alternative remedy when question of jurisdiction of authority, violation of natural justice, and fundamental rights are raised in writ petition. Petitioners raise the question of jurisdiction and law. Therefore, the writ petition is admitted for hearing. Meanwhile, impugned order passed by the collector shall remain stayed. This order was passed on 25/11/20. This stay order has continued until this day. This order is not being appealed against. Now, my lord, may I complete this? Another 4 or 5 dates. Collector of Stamps Bulandshahr, Uttar Pradesh, by an order assessed an amount of 92 crore 50 lakhs as a stamp duty payable on NCLT Allahabad order, because the rate is different in Uttar Pradesh. The amount of stamp duty on INR 32.375 crore as already paid on NCLT Mumbai order was deducted from the above assessed duty, and the petitioner was directed to pay the balance. This is according to the law. The law says when you stamp a document, if the similar document or the copy of the document has been stamped in another state, you will deduct the amount. I'll show the section 29. Petitioner paid stamp duty of INR 60 crore as adjudicated by Bulandshahr. Application number 5673 on behalf of the petitioner before your lordship. Order dated 31/3 passed by Collector of Stamp Bulandshahr. Stamp duty certificate dated 25/5 evidencing payment of stamp duty of INR 60 crore. Counter affidavit on behalf of the state along with application to vacate the stay listed before the court when application number 8469 and 5673 filed on behalf of the petitioner were allowed and the documents were taken on record. 2 weeks' time was sought on behalf of the petitioner to file reply to the vacate stay and to file rejoinder. Matter directed to be listed in week commencing from 31/8/21. Interim relief directed to be continued. Following was filed on behalf of the petitioner. Rejoinder I have filed. Reply to the application to vacate stay. Additional reply filed on behalf of the respondent state to the rejoinder. Due to paucity of time, matter adjourned. My lord, the interim applications may not be relevant because your lordship is hearing the final petition. These are the facts. Now kindly see a few documents, just a handful. The show cause notice kindly see item 15.
So page number.
Sorry, I'm sorry. No, just a moment. To the, this is just to register. Item 14, 37/2019. Office of District Registrar directed petitioner to submit copies. That is at page 373. What? It's all in Hindi. There's no translation. All right. Would your lordship permit my learned friend to
Yeah,
read the
no problem.
I'll read the second one.
No, whatever. I don't know.
उपयुक्त विषयांतर्गत संदर्भित पत्र के तत्समय से लेख है कि इस कार्यालय में मिसेस अल्ट्राटेक लिमिटेड द्वारा वर्ष 2017 में मिसेस जेपी सीमेंट जेपी एसोसिएट्स के मध्य प्रदेश राज्य में बेला जिला रीवा एवं सिद्धि में स्थित सीमेंट स्टेट्स का अधिग्रहण किया गया है। उक्त संबंध में माननीय उच्च न्यायालय बॉम्बे एवं माननीय उच्च न्यायालय इलाहाबाद द्वारा पारित आदेश क्रमांक 16 दिनांक 15/2/17 23/17 दिस इज द एनसीएलटी ऑर्डर्स एवं स्वीकृत स्कीम ऑफ अग्रीमेंट पब्लिक नेशनल कंपनी लॉ ट्रिब्यूनल द्वारा पारित आदेश एवं तदुपरांत रजिस्ट्रार कंपनी को प्रस्तुत स्टेटमेंट के प्रति 1 सप्ताह के अंदर इस कार्यालय को उपलब्ध कराना सुनिश्चित करे। So they asked for the both orders.
Then, my lord, my reply is next page, 5/8/2019. With reference to your caption letter, we are enclosing here with the following documents in connection to acquisition of cement plant, etc., Siddhi and etc. Copy of order of NCLT Mumbai, 15/2, sanctioning the scheme. Copy of order of NCLT Allahabad, dated 2/3. Copy of receipt for payment of stamp duty. Copy of Form NC. So I bring the two documents on 5/8/2019. That is the first. So the relevant date in my respectful submission is 5/8/2019, when the documents were received in Madhya Pradesh. Please see just one or two other documents. The show cause notice at serial number 22, page 429. I'm sorry. Where is the show cause notice? I'm sorry, my lord. I seem to have made a mistake. Serial number 17 at page 378. I'm sorry, my lord. I apologize.
No, this is not the show cause notice, it is the reply to the show cause notice. 370. Achha, sorry, sir.
16.
316, right.
16.
This is the reply, is it?
No, this is not.
No, sir, I'm sorry, sir. Reply is on the next page.
This is under Niyams 6(2).
Rule 6(2).
Rule 6(2) and Dhara 40 के उपलब्ध सिद्धि में मुद्रांक शुल्क की वसूली हेतु कार्यवाही की जाएगी।
No, this is the show cause.
This is the show cause.
Is it English translation available?
The reply is at the back, sir.
This is the show cause notice, annexure P16.
Yes, sir.
And then I filed a reply, annexure P18.
English.
This is in English, my love. The show cause notice is in Hindi, be that as it may. The reply is what I wish to read. All that preliminary is set out. Kindly see paragraph 3. The original instrument dated 15/2 cannot be produced before the authority, as the original order is a part of a court order. We are only given certified copies, only certified copies provided. The scheme of demerger was declared effective on 29/6/2017 by the parties through resolution passed by the respective board. The order of NCLT 15/2, that is the Mumbai order, in compliance of directions was submitted to the Superintendent of Stamps, Mumbai. And they levied 32 crore and I paid 32 crore. The state of MP issued a notification and inserted a cap of 25 crore. 7. The company, via its letter dated 24/10, Principal Secretary, agreed to pay a stamp duty to a maximum of 25 crore with exemptions and other payable taxes. Copy of letter dated 24/10 is marked as Annexure R5. It is pertinent to point out here that duty, which is the nature of tax, cannot be charged merely on the basis of any concession given by a party. The tax duty is payable only if it's mandated by charging section. In reply to the notice for the determination of chargeability, Ultratech categorically submits that the company is not liable to pay any further stamp duty on the said instrument dated 15/2/2017 passed by NCLT Mumbai. My Lord, pausing here, he seems to have accepted it because he's not taken the NCLT Mumbai order. So I have no further comment on the NCLT Mumbai order. Then, relevant date of chargeability. The relevant date for ascertaining the stamp duty in the state of MP for a document which is not executed in Madhya Pradesh would be governed by section 19A. Lord, it's relevant. Your lordships may have seen it previous occasion. The relevant date would be an instrument executed outside Madhya Pradesh and subsequently received in Madhya Pradesh. Thus the document was received by the state of Madhya Pradesh on 24/10/2017 when it is duly submitted by Ultratech before the competent authority. My Lord, that was the legal advice given at that time. 24/10/2017 is serial number 10. I wrote to the Principal Secretary, Department of Commercial Tax voluntarily. According to me, and I have advised my client, the correct date is only 5/8/2019. When I submitted it to the competent authorities, the collector of stamps. The Principal Secretary, Commercial Department is not the competent authority. Anyway, my Lord, I don't
But
want...
it was the claim by the petitioner itself that the relevant date is 24/10/17.
I said so, but I'm saying 24/10/2017 was on the basis of advice. Anyway, it won't make a difference to my argument later. 24/10/17 is not the date on which the document is received by the competent authority. It's a 24/10/17. I voluntarily wrote a letter to the Principal Secretary of the Government of Madhya Pradesh. Only a Mumbai order.
Only Mumbai order.
Only the Mumbai order was enclosed. I'll show that document. Only the Mumbai order was enclosed, and I offered to pay 25 crore. So Allahabad order was never enclosed. No. It says. No, the sentence in page 383. I'm not criticizing the person who made this legal advice. Please see the sentence. Thus, the document was received by the state of MP on 24/10 is factually wrong because Mumbai order was produced before and by the competent authority. Both are wrong. 24/10/2017, I did write a letter enclosing the Mumbai order to the Principal Secretary. We are concerned with the Allahabad order because he is not assessing the Mumbai order. When was the Allahabad, which is the appropriate order, is the Allahabad order. That Allahabad order, which is the subject matter of this writ petition, was submitted to the competent authority only on 5/8/2019. So I would respectfully submit, notwithstanding my statement in the letter dated 24/10/17, which can be explained by saying the Mumbai order was produced before not the competent authority, I am submitting for your lordship's consideration that the correct document before the competent authority, namely the Allahabad NCLT order, was produced only on 5/8/2019.
No, sir, NC, okay, sir, right.
That is a submission, my lord, if your lordships to appreciate. Then kindly see the further reply. To buttress the above submission, reliance is placed on the decision of New Central Jute Mills. That your lordship knows, it's only when the document is received. That is in paragraph 21. 21. There are two dutiable events according to the Honorable Supreme Court. The first dutiable event is the execution of the document. The second dutiable event is when the receipt in West Bengal. Let's kindly see page 384, paragraph 21. The mortgage deed, which is a subject matter of the present petition, was executed in Uttar Pradesh, though it related to property situated in West Bengal and was received in that state for registration. The first dutiable event was the execution, which took place in UP. The second dutiable event was a receipt in West Bengal, emphasis added. So, my lord, two events have to take place before it's dutiable to stamp duty. One, it must be executed outside the state, and the other, it must be received in the
State where the
in
property
the
is.
state where the competent authority is. Then, my lord, I'll read on. I citing this judgment. Then the Gujarat High Court has followed it. And then kindly come to page 385, last paragraph. Therefore, the effective date for applicability of rate of duty is a rate prevailing on the actual date of receipt of the instrument in Madhya Pradesh. Since notification number so and so passed under section 9(1)(a) is in force when the instrument is brought into Madhya Pradesh, the same would apply. That is the capping. Therefore, the maximum chargeable duty, if chargeable at all, in the state of MP upon the said document is capped at rupees 25 crore. Therefore, the maximum chargeable duty, if chargeable at all, shall be rupees 25 crore. Well, the nature of document is as a going concern. I told your lordships that it is a running cement plant. Then at 388, I say no stamp duty payable due to set off. Kindly see, Madam. Documents executed in a state outside Madhya Pradesh and duly stamped in that state and relate to any property situated or to any other matter or thing done or to be done in Madhya Pradesh and is received in Madhya Pradesh are liable to be stamped in Madhya Pradesh as per section 3BP of the Madhya Pradesh Stamp Act. It has been clarified in New Central Jute Mills that is only the difference between the amount already paid in the instrument and the duty leviable in Madhya Pradesh, if any, is required to be paid as per section 19A1. Now kindly see section 19A1. (19A1). (19A). Payment of duty on certain instruments liable to be increased duty in Madhya Pradesh, etc. Where an instrument has become chargeable in any part of India other than Madhya Pradesh, with duty under this Act or under any other enactment for the time being in force in any part of India, and thereafter becomes chargeable with a higher rate of duty in Madhya Pradesh under clause BB of the first proviso to section 3, the amount of duty chargeable on such instrument shall, notwithstanding anything contained in the first proviso to section 3, be the amount chargeable on it under Schedule 1A, less the amount of duty, if any, already paid on it in India. In India. So you charge it under Schedule 1A, but give credit to the duty already paid on it in India. What? What is 90 business? No, not necessarily, notwithstanding anything in proviso. Then, my lord, may I read on? page 389, paragraph 3. The result will be that if an instrument, after becoming liable to duty in one state, on execution there becomes liable to duty also in another state, it must first be stamped in accordance with the law of the first state, and it will not require to be further stamped in accordance with the law of the second state when the rate of the second state is the same or lower, and when the rate of the second state is higher, it will require to be stamped only with the excess amount, and that in accordance with the law and the rules in force. Therefore, Ultratech is liable to pay only the excess stamp duty payable in Madhya Pradesh over and above what was paid in the state of Maharashtra. Well, again, there's a confusion in the minds. The Bombay document was not the subject matter of here, although he asked for it. It is the only subject matter is only the Allahabad document. Therefore, Allahabad rate and the Madhya Pradesh rate must be compared. Anyway, my lord, I can't hide this fact that I've written this reply. I'm making legal submissions. The maximum duty, if at all payable, is 25 crore, which is less than the 32 crore, etc., etc. Then no stamp duty required to be paid on order passed by NCLT. NCLT passed an order approving the scheme, instrument which is an order, etc., approval of the scheme. Second instrument is the same transaction. Several instruments used in single transaction. Well, I can choose which is the first original instrument. Where in the case of any sale, mortgage, or settlement, several instruments are employed for completing the transaction. The principal instrument only shall be chargeable with duty prescribed in Schedule 1A for the conveyance, mortgage, or settlement, and each of the other instruments shall be chargeable with a duty of 6 rupees instead of the duty. The parties may determine for themselves which of the instruments so employed shall, for the purposes of subsection 1, be deemed to be the principal instrument, provided the duty chargeable on the instrument so determined shall be the highest duty which should be chargeable in respect of any. My lord, the writer of the letter, obviously on advice, decided to choose the Mumbai instrument as the principal instrument and the Allahabad instrument. My lord, that can be argued, but I'm not going to dwell on it in this case, because I think, this is my opinion, NCLT Mumbai is one order. NCLT Allahabad is another order. It's not a copy of that order. I mean, you can't say. It's the same scheme, but the author of the order is different. And I would not venture to say it's a copy of the order. If it's only a copy of the order, you can choose the principal order. What is the principal instrument, and choose the copy will be charged at 6 rupees. I'm not arguing that. Parties involved in the instrument of the absolute right, etc., submitted the proviso of applicability, etc. Therefore, in the humble submission, thus is necessary, please to close all the proceedings relating to the recovery of any stamp duty. This is the detailed reply I've given. My reply is, please drop the proceedings. I'm not liable to pay anything. Then, my lord, this is page, what I read.
Yeah, that is your page.
Detailed reply. Serial number 18, 5820. Now just look at the dates. What happens after 5820? 5820, after that, only the government of Madhya Pradesh notified the Janpad Cess at 1%. Petitioner filed an application before Collector of Stamps Bulandshahr for adjudication. And on 1910, I informed him that I filed it on Bulandshahr. Nothing else has happened from the respondent side. The show cause notice he gave. Which is that? Nothing happened after my reply between 5820 and the impugned order of 24/10/20. The last order from him was at page 373, 37/2019, serial number 14, asking me to submit copies. That's all. So he asked me to submit copies. I have filed the copies. Then at page number 17, issued a show notice under 48B. That is at page 378. 8. Number 3, annexure P16.
378. 378. This is what we read.
No, I've not read it. Nobody has read it.
I just read the last line of this.
No, your lordship may read for yourself 378. I'll ask my learned friend to read.
Yeah, I have read, but it is mentioned that since the original instrument has not been filed, therefore, why should not we presume that it is improperly stamped and why the entire stamp duty may not be recovered? That is the gist of that show.
That's the gist of it. He is not proposing anything about the Janpad Cess or the one Panchayat Cess. He is not proposing penalty. And how does he pass an order on all these 4 matters without issuing a show cause notice and hearing me? If he is imposing penalty, he must show cause to me. If he is imposing Janpad Cess at some other rate, except that the other than the rate notified by Madhya Pradesh government, he must notify me. If he is taking immovable property, he must show cause me. He has done nothing of that sort. I hope I'm making myself clear. He has done nothing. And if your lordship now look at the impugned order, which I've extracted the 4, I'll read the order. Now, stamp duty of INR 123. Has he proposed 5% here? That's 378. But in 378 page, he has not proposed 5% rate on immovable assets. And why he will not take the cap of 25 crore, he has not given reasons. But he has imposed 5%. Then the second one on movable assets, no reference to that at page 378. Upkar says no reference to that in 378. Janpad says no reference to that, and he ignores the government of Madhya Pradesh notification. And penalty, which is the worst, he must show cause me for penalty. He's passed an order. So I said all 5 elements of the order are totally arbitrary, in violation of principles of natural justice, without jurisdiction, and in violation of law. Just a minute. The impugned order, now kindly see the impugned order. At 429. The so-called order to submit is only 2 paragraphs. And the impugned order, of course, runs to several pages, but that's okay. Which portion?
So it starts at 4:30. Says 4:30. Second March. First page.
Kindly see at page 430.
That is the translation version.
Translation.
The Hindi version.
The Hindi version is at page
409 onwards.
Yeah. Wait. On not finding the order dated 2/3/2017, passed by the National Company Law Tribunal at Allahabad, an approved scheme of arrangement produced by Ultratech Cement, to be duly stamped. The case under 48. I accept it. He is only taking the Allahabad order. He is not taking the Mumbai order. Fair enough. Case is taken under 48B. On the basis of photocopy of the order, Millard, it is actually a certified copy of the order, be that as it may. Regarding the order passed by National Law Tribunal bench at Allahabad, an approved scheme of arrangement, by letter, it was directed. A aforesaid order is an instrument under Indian Stamp Act, and the aforesaid instrument was not got registered by Ultratech with a view to evade stamp duty, whose stamp duty to be recovered. Case was registered. By issuing notice to the non-applicant company, it was directed to produce the original instrument. The original copy of the impugned instrument was not produced. Therefore, it was presumed that the original instrument is not duly stamped and proceedings for recovery of penalty. Hopelessly wrong, Malab. There's no original and court order and a copy of it's a certified copy. This is the reason why he is imposing penalty. This is no ground at all. On behalf of the non-applicant company, submitted detailed reply as well as written and oral arguments.
What is the seat called for us on that day?
On 9, 6 and 5, 8. The case was carefully perused by me and therefore directed to pass order. The brief facts of the case.
He's focusing only on second.
Just simple. Brief facts of the case. All that is set out, Mala. Then, page 433. Whether the order dated 2-3 passed by the National NCLT Allahabad are duly stamped. Whether the chargeability of stamp duty on the order dated 2-3 will be affected by the order of NCLT Mumbai. Amount chargeable in the order dated 2-3. Non-applicant oral as written reply has asserted these points. Not all that is a repetition of my reply. It would be page 437. It would be justifiable to do the point-wise examination of the written and oral arguments. Regarding point 1, it is clear. Where order dated 2-3, NCLT Allahabad, transfer of all the properties, etc. was effected. Neither the aforesaid instrument was got registered, nor the stamp duty was paid. Non-applicant in his reply admitted he has not paid any fees on the order dated 2-3 passed by NCLT Allahabad, an approved scheme, due to non-chargeability of any fees. Therefore, it would be appropriate to peruse the provisions of 214. 214, instrument includes every document which any right or liability, no quarrel. Honorable Supreme Court in Hindustan Liba. All that is set out over the page. Regarding the aforesaid order dated 2-3, it would be appropriate to peruse the provisions of 2-6, chargeability. Regarding the orders of tribunal, it is clear that the date of the order is itself the date of execution. The Honorable High Court in the manner of Chief Controller, etc. And that is extracted over the page. Therefore, the order dated 2-3-17 passed by the NCLT Allahabad is an instrument under section 214. So far as the question of the order dated,
Yeah.
2-3.
Yes, sir.
Therefore, fees is chargeable on the date of execution. What he ignores is the date of receipt in Madhya Pradesh. I've made that. So far as the question of the order dated 15-2 of the NCLT Mumbai is concerned, the aforesaid order, the transfer of property is not got effectuated. The same is getting under process. Section 7 makes it more clear. That is extracted. Neither the non-applicant company is entitled to transferable property, nor is authorized to dispose of transferable property which is not his own. Therefore, so far as the question of order dated NCLT Mumbai is concerned, the transfer of property of the non-applicant company is not getting, my lord, I don't understand this, and it's irrelevant because he's not stamping that document. Regarding point 2, it is clear that on the basis of the order dated 15-2-2017, passed by NCLT Allahabad, an approved scheme, an amount of so-and-so has been paid by non-applicant company in Maharashtra. The facts mentioned in point 2 are undisputed. Neither transfer of rights and etc. getting effectuated and the perpetuating. It merely appears to be the acceptance for anticipation of transfer. Regarding point 3, the provisions of Indian Stamp Act are fully clear. All that is then, because aforesaid instrument has been received in Madhya Pradesh on this very date under section 19A, and the same would come under the maximum limit of 25 crore as prescribed by notification dated 3rd July. Regarding the aforesaid document, the non-applicant has placed reliance on the judgments of the Honorable Supreme Court and High Court. It would be appropriate to peruse the provisions of the Indian Stamp Act. 211 is extracted, 19A is extracted, which gives set off over the page. From the aforesaid provisions, it is clear that at the time of execution of all the documents executed in India, same should be stamped, and the date of order passed by NCLT Allahabad, that is 2/3/2017, is the date of execution. The provisions of section 2(6) would apply regarding the rate of chargeability. since the Honorable Supreme Court in the case as referred to by non-applicant has held that charging event is the execution of the document and the law to be applicable is a law in force on the date of such execution. Similarly, in the matter of media anusuyam, the Honorable Court has explained that the date of execution of the document is relevant for levy of stamp duty and not the date of its presentation in court. Moreover, it has also been held by the Honorable Court that the substantial date for determination of fees under schedule is the date of execution. Honorable Kerala High Court in the state of Kerala, that is extracted. And over the page, my lord, at 448. It has been held by the Honorable High Court of Andhra Pradesh. So under section 2(6), chargeable means as applied to an instrument executed or first executed and is applied to any other instrument chargeable under law in force in India. When such instrument was executed or by several persons executed, it may be noticed that according to this definition, what is liable at the time of execution. For the aforesaid reasons, due to the date of being execution being 2/3/2017, passed by NCLT bench at Allahabad, the notification dated 3/7/2017, that imposes the cap, won't be useful in the present case due to coming in force after the date of execution and due to not being in force at the relevant point of time. The argument is not accepted. This is the ground is raised. 2/3/17 is the date on which I have to decide the taxability, and the exemption notification came later on 3rd July 2017. Regarding point 4, non-applicant has placed reliance on the judgment. It is not required to be stamped. That is a set-off, Mara. Order stamped, etc., passed by the etc., not the order dated 2/3. Regarding section 19, the Honorable High Court and the etc., whether the instrument in respect of amalgamation or compromise between the two companies as such a scheme are incidental to computation of stamp duty. Answer: the orders of the court sanctioning a scheme of amalgamation are not just incidental orders, even in accordance with the scheme. Such a scheme becomes operational effective. Computation of stamp duty and valuation does not make scheme of amalgamation alone chargeable. The order is an instrument. Whether for the purpose of section 19, the scheme compromise between the two companies must be construed as document executed outside the state. Answer: basically, a scheme between the two companies is never a document chargeable to stamp duty, whether such document is executed in the state outside the Maharashtra. Moreover, in view of the conclusions above, section 19 in any event has no application. Therefore, in the light of the aforesaid judgment, this argument of non-applicant is not acceptable. In point 5, again, the non-applicant has argued regarding time of stamping, where it's been made clear in the examination of point 3, the question is not of the time of stamping, it is a question of chargeability, which according to the Indian Stamp Act, etc., the duty should be calculated on the date of execution. Similarly, the Honorable High Court, that is a repetition of the Andhra judgment. In point number 6, again, the non-applicant has pointed out notification date 2/1. According to the aforesaid notification, that is the original notification, 10 crore, that is irrelevant because it has been superseded by the new schedule and the new exemption. Then, my lord, kindly come to page 455. All that is beside the point. Kindly come to 457, foot of the page. In this point, the non-applicant has pointed out notification, etc., dated 19th August of the Panchayat and Rural Development Department regarding Panchayat duties. Aforesaid notification was also not in force on the date of execution. Since the fees has to be calculated on the date of execution, therefore the notification dated 19/8/20 would not apply in the present case. Accordingly, this argument of non-applicant is also not found acceptable. Regarding point 7, it is pertinent to mention that during the analysis of point number 3 and 6, it has already been declared that maximum limit, etc., would not apply in the present case because the date of execution is 2/3. It has been made clear in point 2, the same is not related to the impugned instrument. Therefore, accordingly, the argument is not found acceptable. Then, at 460. Regarding point 8, it has already been clear during analysis of point 2. Actually, the order dated 2/3 are effectuating the transfer and the duty is chargeable of the same, it would be appropriate to go through the provisions of section 4. That is extracted. Then Melody cites case law on section 4. Then he comes to 463, the paragraph. It is no need to reiterate that the provisions of section 4 are not applicable on the order dated 15/2 passed by NCLT Mumbai and the order dated 2/3 passed by NCLT Allahabad. Therefore, the argument of non-applicant is unacceptable. Regarding point number 9, it is submitted. There is no question of transfer of running property. In fact, under the first proviso to Article 25, it is an instrument under orders of tribunal, etc. Therefore, the stamp duty will be calculated on the basis of movable, immovable, and leased property situated in Madhya Pradesh only in accordance with the procedure. Although the judgment of the Honorable Court, which has been referred to, the facts of the case are totally different. Honorable Court has held all industrial units are movable properties. Regarding the above, it would be appropriate to go through section 326. Immovable property shall include land and things attached to land are permanently fastened. He goes into this distinction between immovable and movable, ignoring the language of the article of the schedule that is invoking. Regarding plant and machinery, comes to the conclusion it's movable. Same views also been expressed by Honorable Supreme Court, all that. Then Milord kindly come to 469. Therefore, after perusal of the facts of the aforesaid, question number 1, it is clear that due to being the order dated 2/3/2017, passed by the NCLT Allahabad, an approved scheme of instrument as amalgamations instrument, same way chargeable with stamp duty on the date of execution. The chargeability for the aforesaid instrument had to be assessed on the date of execution, but due to non-payment of any stamp duty in accordance with the first proviso to Article 25 on the aforesaid order, the said instrument is not found to be duly stamped. Now, after perusal of the facts of question 2, the chargeability of the stamp duty on the order dated 2/3 passed by NCLT Allahabad is not affected by the NCLT order Mumbai, etc. All that is, again, he goes into that same thing. Then, page 471, transferor company has not paid any stamp duty on the order passed by this court, either in Gujarat or Maharashtra. He obviously doesn't understand how a tribunal functions. Nobody in the tribunal asked me for stamp duty. They adjudicate the matter and pass an order. That is not execution. It is an order of a court, whether in a scheme compromise, etc. Therefore, the stamp duty 323 crore paid by the earlier, 32 crore paid by the earlier cannot be adjusted. In question number 3, so far as the question of chargeability of stamp duty is concerned, he now divides it into leasehold land, mining restoration, freehold land, building, plant and machinery. Please see, Milord, he has put plant and machinery 115 crore, which is, according to him, on perusal of the valuation sheet, total immovable properties 2,461 crore. Total movable property is 613 lakhs. Under the proviso to Article 25, the stamp duty on immovable property is 5%. According to Madhya Pradesh Cess Act, the 10% of stamp duty is assessed. Under the Madhya Pradesh Panchayat Act, 1% of immovable property is assessed, etc. And in the assessment of the Honorable High Court regarding the penalty in the matter, total amount payable is 209%. Milord, your Lordship may kindly read the Hindi, because the translation I may read may not faithfully reflect the Hindi, but sum and substance, Milord, I'll wind up. Sum and substance, he says, 2/3/2017 is the proper date for me to charge duty. I am charging under Article 25 proviso. of Schedule 1A. I am taking 2/3/2017 and applying 5% because the capping came on 3rd July 2017. I am assessing only the Allahabad order. Allahabad order is executed, to use his word, 2/3/2017. And for that same reason, once I charge duty at 5% as on 2/3/2017, I will apply 10% of the stamp duty as one cess and 1% of the stamp duty as another cess. And for the 1%, he says, the notification came only in 2020, namely 14/10/2020, and it's no relevance to 2/3/2017. And since this is the inexplicable part, since neither stamp duty was paid in Mumbai or stamp duty was paid in Allahabad on 2/3/2017, it is a non-stamped document and therefore I'll impose penalty. This is broadly his argument. I submit, my lord, every part of the argument is wrong. 2/3/2017 is not the relevant date. Kindly see the act again. Which section? 3BB. No, not 3BB. 19. Received. 19. Man. Section 19. (19A), isn't it? 19. Where any instrument has become chargeable in any part of India other than Madhya Pradesh with duty under this act or under any other enactment for the time being in force, and thereafter becomes chargeable with a higher rate of duty in Madhya Pradesh under clause BB of the first proviso to section 3, the amount of duty chargeable on such instrument shall, notwithstanding anything contained in the first proviso to section 3, be the amount chargeable on it under Schedule 1A, less the amount of duty if already paid on it in India. Such instrument shall, in addition to the stamps, if any, already affixed thereto, be stamped with the stamps necessary for the payment of the amount of duty chargeable in it under clause 1 in the same manner and at the same time and by the same person as though such instrument was an instrument received in India for the first time at the time when it becomes chargeable with higher duty. Now, 3BB at page 12. It starts, my lord, at page 11, instrument chargeable with duty, 3BB, respectively, BB. Every instrument mentioned in Schedule 1A that chargeable with duty under that schedule, which not having been previously executed by any person, is executed out of Madhya Pradesh on or after the commencement of the Act and relates to any property situated or to any matter or thing done or to be done in Madhya Pradesh and is received in Madhya Pradesh. My lord, my respectful submission, it allows only one interpretation. A court order is not executed by any party. Court order is pronounced by the court. When on the basis of the order of court, I want the property in my name, I'll have to produce it before various authorities for mutation, etc. I produce it in Mumbai, I pay stamp in Mumbai. I produce it in Allahabad or Uttar Pradesh, and I pay stamp duty in Uttar Pradesh. The dates may be different. We are concerned only with the NCLT Allahabad order because he's not purporting to tax the NCLT Mumbai order. The NCLT Allahabad order was produced before the competent authority in Bulandshahr, Uttar Pradesh on,
But it's much subsequent to the proceedings, which had already initiated in Madhya Pradesh. Just few days prior to passing of the impugned order.
yes, correct. No, it is before the impugned order.
Just few days prior to the impugned order, but much after the initiation of proceedings in Madhya Pradesh.
Correct. Absolutely correct. Your Lordship is absolutely correct. I submitted it in Madhya Pradesh when it was necessary for me to submit it in other.
Fine.
I mean, I submitted it in Uttar Pradesh when it was necessary for me to submit it.
But even on the day when the impugned order was passed,
Yes.
there was no order by the Bulandshahr authority.
No, Bulandshahr order came later.
It came later. So on the
I
day
had
when the
submitted
impugned
it earlier on 14/10. Impugned order came on 24/10, and the Bulandshahr order was passed on 31/3/20.
21.
Your Lordship is absolutely right. So Allahabad order, when it was received in Madhya Pradesh, was on order which was produced in Madhya Pradesh and received in Madhya Pradesh on 5/8/2019. That is the point I'm making. Not 2/3/2017
For 24/10/17.
or 24/10/2000, because 24/10/2017, I only produced before the professional, the secretary, the Bombay order. I didn't produce the Allahabad order. I produced only the Bombay order, and he's not taxing the Bombay order.
Sir,
When was, your Lordship may ask the state, if Lordship pleases, when was the Allahabad order produced before the competent authority in Madhya Pradesh? I submit the answer is 5/8/2019. 5/8/2019, it was an order which not yet subjected to tax in Uttar Pradesh, but the same order had been subjected to tax in Mumbai. And I'm telling him that you tax this and I will pay. If you tax it at 25 crore, I would have paid it. He says, no, the 25 crore cap later,
came later on, therefore it is not.
2017, I will not. He is fixed on 2/3/2017. If your Lordships will take 5/8/2019 as a relevant date,
Then cap of 25 crore will be there.
25 crore will be there. 25 crore will be there. Now the question is, so 25 crore, I don't have to dilate on it. According to me, 5/8/2019 read with 25 crore. Those are the two relevant dates. As far as the 10%, it says 10% of stamp duty. Once the stamp duty issues resolved, 10% resolves itself. The 1%, he says, the notification was not there on 2/3/2017. The notification came later, but there's an executive order came earlier. Executive order came on 6/10/2018. See, item 13, 6/10/2018. In the process,
Whether in taxing statutes, the executive orders can,
it is a
comment.
special order.
maybe, but whether the executive order can change the taxing statutes.
No, my lord, it is not changing the statute. It is under the statute. The
No,
notification.
whether the statute permits the government to issue an executive order,
Yes,
which is that, sir, provision.
please see. Where is that order? Notification. Notification. 25, page 375. What is the power exercise? No, what is the power exercise? Kindly see, my lord, under section 75 of the Madhya Pradesh Act. Madhya Pradesh Panchayat Raj and Gram Swaraj Act.
Within a Panchayat Raj and Gram Swaraj.
Act. Now I am saying, please see the language.
Sir,
1% amount of the imposed stamp duties shall be taken from the applicant company. So it is only after imposition of stamp duty, the 1% shall be taken from the applicant company. So this notification will apply only after imposition of stamp duty.
stamp duty.
Whenever you impose stamp duty, this notification is there. You impose stamp duty only on 24/10/20. Immediately 1 minute later, 1 minute later after you impose stamp duty,
It will become chargeable.
it will become chargeable only under 1%. The notification was there. Therefore, my lord, he can't say 1% on 2/3/2017. That is irrelevant. And then penalty, which is the penalty provision? Huh? No, penalty provision. Yes. Now kindly see the penalty provision. Section 40. No?
Yes, 40.
I'm reading. When the collector impounds any instrument under section 33, did not arise, no impounding here, or receives any instrument sent to him under subsection 2 of section 38. 38(2) is also impounding authority, sends it to the collector. That was not the case here. Or receives any instrument, not being a receipt or a bill of exchange, he shall adopt. Neither of the two preconditions applies. It was not impounded under section 33, nor was it sent to him under 38(2) by the impounding authority. B. If even so, after holding an inquiry, he is of opinion that such instrument is chargeable with duty and is not duly stamped, he should require the payment of the proper duty together with a penalty of 2% of the division portion of the stamp duty for every month or part thereof. Where did he propose to me that he will impose penalty? How can he propose a penalty, Melon, without even telling me I propose to impose a penalty? I would have pointed out to him. Therefore, my lord, every one of the 5 elements of his order, which I have extracted in the list of dates at serial number 15, at serial number 22 is wrong. This order must be quashed. He must be asked to redetermine. I will make my submissions before him, my lord. What is the law today? What is the law today? After applying, of course, your lordship's judgment, if your lordship is pleased to accept my submission and quash the order, and then he can. Milord, actually, I would have had no problem paying 25 crore and walking away peacefully. But they didn't accept that offer of 25 crore. They wanted to go through this process and look at the result of that process, 297 crore, writ petition, etc., etc.
Jesus, who is for this state?
But I was only praying, Lord, we'll start tomorrow, Lord. Because
खत्म करेंगे आज ही.
these are, it will take some time.
Oh, yeah.
There was last year, last.
At least I have a history of sitting up to 9.
No, that is there, Lord, but if,
You don't want to break that history.
no, we go down to that history, Lord. We'll start tomorrow, Lord, if you're not.
Please continue, sir.
Lord, because I'll also pray, Lord, that the learned advocate general is supposed to argue this matter, Lord. He just traveled from Delhi, he just reached. So if you're not,
I think he has also come from Delhi, sir.
but my learned senior, I suppose, is here since the morning, Lord.
What is the matter about? So what is your stand?
If your lordship may allow us to start tomorrow, Lord, we'll be grateful.
Let us finish tomorrow today itself. Sir.
I would insist, Lord, most humbly that if your lordship may permit us.
My humblest request is to finish it off today itself.
Lord,
One person more than your humble request. Mr. Rupra, generally I never refuse to grant such a request, but
yes, Lord, that's what I'm.
he is an outstation counsel. I don't
Lord,
know whether he will be staying back for tomorrow or not.
Lord,
Had it been a case that it was argued by a local council, I would have requested the local council, please come at
Lord,
10:15.
they informed us, Lord, we would have.
No,
We
no,
never
no.
had the
You
information.
must be surprised that why I'm not listening to your request. I'm trying to draw a distinction. Had it been a case that the case was argued by a local council, I would not have refused to accommodate you.
Lord,
Generally, I say, okay, we will conclude on the next day because local counsel is also here. In case if he wants to respond, he will get an opportunity. But I don't know whether he will be staying back or not. If he is staying back, then fine. But if he is not staying back, then I cannot compel him to stay back.
Lord, then we will argue, Lord, he can very well leave, Lord.
And then without giving an opportunity to him to answer.
Lord, if I may most humbly inquire whether the senior is available tomorrow, Lord, we continue. Because the understanding was that.
You may inquire from me. You may inquire from me, no difficulty.
If I may ask you, please. Tomorrow, we'll argue. Yes.
Very well, Malal.
Then at 10:30 sharp,
Yes.
first case. Sir.
Yes.
Malal, can I think I read the judgment while reading the list of dates, but I'll show Justice Das Gupta's judgment in New Central Jute. This is the only judgment which I wish to cite. It's a constitution bench. My mark copy. I've got it. New Central.
Jute Mills Company Limited.
Yes. No. The order is cited this, but in the context, now please see paragraph 16 onwards, just a few paragraphs. Actually, it's 4 paragraphs. Some complications arise in the cases where both the liabilities arise. That is where given the other side of copy, whether the instrument is executed in one state, but is related to property situated in or to things done or to be done in another state and is received in the second state. In these cases, the liability to stamp duty arises first under the stamp law of the first state on account of execution in the state. The second liability arises under the law of the second state when the instrument is received in that state. How is the liability to be discharged? Has it to be discharged in accordance with the law in force in the state where execution takes place, or in accordance with the law in force in the state where the second dutiable event, that is the receipt in the second state, occurred? Obviously, an officer of the first state may reasonably think it is a law of his state which must prevail. So even if the document has been stamped in accordance with the law of other state, he may ignore that stamping as not done in accordance with the law in India and proceed to demand that it must bear the stamps in accordance with the law of his state. It was to avoid the hardships that may conceivably result. Legislature of different states enacted section 19A. That is the credit. I'm not reading the section. Therefore, where the rate of duty in Uttar Pradesh for an instrument which
Suggestion
becomes.
is that if the rate of duty in the second state is higher than the rate of
Yes.
duty prevailing in the first state, then only the excess amount can be recovered.
I
And
am,
if the rate of duty is same or lower, then this second state can't recover anything.
absolutely. The important point is the second line, second dutiable event. Please see paragraph 20. It reiterates that point. The result of this will be that if an instrument, after becoming liable to duty in one state on execution, therefore becomes liable to duty in another state on receipt there. So that there's a two dutiable events. One is the execution of the document. We are not concerned with that because it was not executed in Madhya Pradesh. Wherever it was executed, that state will take care. Your dutiable event arises only when it is received in your state. I ask myself, when was it received? It was received in my respectful submission on 5/8/2019. That is why I'm relying on this, Chair.
Second.
Oblige, madam. I will be present tomorrow, madam.
Grateful.
He's rising.
But sir, minimum courtesy which was expected from the state was to
Yes.
inform the outstation council. Is that SAC
With the greatest of respect, we did not know that my learned seniors.
No.
Might be, but you should have informed your local council also, inquired from that.
I
Once,
inform him, but I think it's not my duty to inform the other side I'm coming.
once
Cases
there is a fixed date case
Yes,
specifically listed before this court,
yes,
there is every possibility that it shall be taken up,
yes.
right?
We will, sorry, sir. We'll take care of that.
I never expect that you should inform me well in advance because I never come after going through the files. I open the files in the court itself. And the reason is that I never make my mind
Yes,
that what should be the result. I always decide after hearing the arguments. So I never open the file in my house. Whatever the file is, it is there. I will take up the case. So I never require any prior information. But so far as the lawyers are concerned, they can't come without preparation.
yes, ma'am. My apologies to your lordship and to my learned
Sir,
senior.
don't apologize to me because I never open any file in my house. I open it only after the case is heard. Because sometimes after going through the file, sometimes we make up our mind, right? And thereafter it becomes very difficult for the lawyer to change the mind of a judge.
Yes.
So it is better not to go through the file. Go through the file along with the lawyer. Then interpret and appreciate as per the submissions of both the parties and then apply my own mind and then dictate the order. I always open the file, apply my own mind only after hearing the arguments of both the lawyers. So it's like I don't require any prior information कि पहले बता देते, otherwise I would not have read in the night. But so far as the lawyers are concerned, they can't have that much of prerogative which I am enjoying of not preparing the file in the night. You should have informed. And अगर आपने संजय जी से बात की होती, he would have immediately informed you that so and so is coming. And I don't think that there is any requirement of law that the opposite party must inform that.
No, that's it.
It was for you because you were asking for adjournment. It was for you to approach the opposite party कि भी ऐसी difficulty. But you are lucky that he could not conclude prior to 4:30. Otherwise, I would not have granted any time to you. So you should be thankful to Mr. Chidambaram also.
Yes, absolutely, I am. Absolutely.
Anyhow, sir,
Obliged.
Great.
that was not on a lighter side, but this is what it is expected.
Yes,
Sure.
great.
उसमें लिखने ना Shri P. Chidambaram, Senior Advocate, with Shri
Ashish Prasad.
Ashish Prasad, for the petitioner, Shri H.S. Rupra, counsel for the state. Arguments could not conclude. Call on calculate. The case shall be taken up at 10:30 a.m. irrespective of the serial number at which it might be listed.
Great.
So सारे नाम लिख दीजिएगा। हाँ, दे दो ना पास।
Item number 9. Lordship, in item number 40, there is a notification, Lordship. There is a notification
देखा ना?
prior to this order.